Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's cases are Lincoln Sponsor LLC versus Wellington and Newport Gardens Apartment LP versus Surlace, 2024 Brooklyn Housing Court cases. First, let's set the stage with some context. It is required by statute that before your landlord can attempt to evict you for not paying rent, the landlord must serve you with a 14-day rent demand. But that rent demand needs to be prepared in a certain way. And if it is not, the case against you can be dismissed. Why? Why is a rent demand so important? I am taking this language from one of today's cases, which itself is citing authoritative case law. The purpose of a rent demand is to, quote, provide the tenant with actual notice of the alleged amount due, the period for which the rental claim is made, and an approximate good faith sum of rent due for each such period. Put another way, in my own words, the purpose of the rent demand is to get the tenant to pay the rent so that the tenant does not need to be sued. If the rent demand is confusing or leaves the tenant with questions, then the tenant either will not know what to pay or the tenant can easily be pressured into paying too much. Therefore, in New York State, a rent demand on at least 14 days' notice is a statutorily required predicate for a summary non-payment proceeding. So that's the background you need. Now let's get into today's case. We're doing two cases today, and they're both out of housing court in Brooklyn from 2024. In one case, here are the problems with the rent demand. The rent demand states only the total amount the tenant owes, which was about $9,000. The rent demand does not itemize what months are due. Rather, the rent demand instructs the reader to see the attached ledger. The attached ledger is hard to read. For one thing, it begins about 8 months before the rent demand was served with a balance forward of $3,000. So remember I said $9,000 is due and owing. It says the rent demand. And then when we look at the itemized ledger, it starts 8 months earlier with a $3,000 balance, just a big lump sum that's a third of the total alleged owed. It simply says balance forward. As of 8 months ago, it doesn't explain where that lump sum came from. The rent demand is confusing. It doesn't explain what is owed. The judge dismissed the case. The other case, the problems with the rent demand are, now keep in mind in this case, the landlord only was suing for $1,737, $1,700. Yet just like the last case, the arrears are not itemized. The rent demand refers you to a ledger which is attached to the rent demand. But this ledger is 6 pages long and goes back to 2016, 8 years of history, which is crazy for a $1,700 balance. Further, the ledger contains additional charges for various non-rent things like cylinders and key fobs. That makes it even more confusing. And the ledger contains adjustments where the landlord gave the tenant credits, presumably for Section 8 payments from the city, but it doesn't label them that way. It doesn't explain what payments, no check numbers, no dates. You really are left guessing as the reader of this ledger. So the judge states, a reasonable litigant would have trouble deciphering from the ledger the amount needed in order to prevent litigation. Case dismissed. So this gives rise to some pretty important tenant takeaways, but first, Housekeeping. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. If you like our work, please give us those 5 stars and put this podcast on your socials. It is time for the tenant takeaway. Tenant takeaway time. This topic can come up as an issue between a landlord and a tenant even before there is a court case. If your landlord is informally telling you that you owe something and you're unsure what you owe, and you cannot figure it out by looking at whatever ledger the landlord sends you, or you can't tell what it is by looking at the tenant portal for your building, then ask questions. As to the court part of this, first, some general commentary by me. The whole point of the predicate rent demand served on at least 14 days' notice is so that the tenant has an opportunity to cure her default and stay out of court. If the rent demand is gobbledygook, it defeats that purpose. It actually makes it harder for the landlord to get paid. If a landlord's goal is to pay lawyers to lose, this is a great strategy with these ledgers. If a landlord's goal is to get paid, then the rent demand should explain simply and clearly what is owed. Adding a complicated ledger is not the same as explaining what charges are still open. If a tenant disputes that she owes the money, then it might make sense to introduce a more detailed ledger going back and showing clearly all the debits and all the credits in the relationship, either informally in a settlement talk or at a trial as a piece of evidence, but just sticking 6 pages chronicling 8 years on the back of a rent demand for $1,700 seems a little nuts to me. I think a lot of the fault lies with the managing agents who utilize these management platform tools with accounting widgets, where it's garbage in, garbage out, and they're not using their own technology to document what's going on with the debits and the credits. I don't know, that's just my guess. That's a lot of what I see. Now, I must point out that today's topic, we're talking about a procedural defect in a landlord's case as opposed to a substantive one. In other words, today we're not talking about reasons that these tenants do not owe the rent. We're talking about the fact that the landlord did not properly sue for the rent. So even if these cases are dismissed, the landlords will presumably make new, better rent demands and the cases will start again. Is that useful for tenant? That is an open question that depends on your circumstances. Sometimes pumping the brakes on an eviction case has great value for a tenant because the tenant needs more time to get the money or to move. Also, slowing the landlord down and pointing out landlord mistakes arguably creates some space for the parties to discuss settlement. But these benefits are not always applicable in every situation. This is just something else for you to think about. The real takeaway is that if your landlord is telling you there are arrears, whether there is a court case or not, and you do not agree that there are arrears, or you do not agree with the amount of the alleged arrears, the landlord must be able to explain to you and defend what they say is due. And there you have it. Remember, New York City, the law belongs to you. But your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.